So Gary, how does an association actually enforce its rules?
Well, if they have rules, and typically within an association, they also would have then a fine schedule. So through fines, they would enforce their rules. Now, there's a whole process in California for us. There's a process of notifying them of a violation. There's a time frame that you have to notify. If they don't remedy or solve that violation, then they can be called to a hearing. Again, with time constraints, you need to meet certain deadlines to notify them, call them to a hearing. The board hears whatever they might have to say about that violation, and then the board makes a determination whether they have worked out a solution without fines, or they may issue a fine.
What happens if the owner doesn't show up for the hearing?
Well, the board can still have a hearing without the owner, and they can still make a determination. So then they would follow that hearing up with a letter, basically with their decision. And maybe it's a $50 fine, let's just say that. So they send that letter out, they've issued a $50 fine for this violation. The owner then gets the letter, and then a whole process from that point can begin as well, where the owner might contest it then. Or the owner might say, well, I already fixed it. I moved my trailer that's not supposed to be there. The board can always rescind that fine at that point. Really, when you talk about enforcement, you're not trying to make money as a board. You're trying to have compliance within the association with the rules. So boards should look at it from that perspective.
What happens if, and I know this happens a lot in associations, where a homeowner doesn't comply, even though you find them and you you follow your policy. But what if it's a safety issue for a neighboring home or a neighboring unit? What can a board do in that situation?
Well, I had an example of that where some trees in the front yard were precarious, and the owner was not responding to letters, was not doing anything about the dangerous trees, the limbs that could have fallen and hurt some people. So we gave proper notice that was outlined within the documents, and after that we hired a company to go on that property and to remedy the safety hazard there. That owner came out and was upset at first, but then he paid the bill and asked them to do some extra work. So it worked out well in that situation.
So when the work's done, in that situation it worked out perfectly, but in the event that the owner wasn't on site and the work was done, the association can charge that owner back for that work.
They can. Now you have to be careful about going on someone's property, though, and I would always say consult your attorney. It's not always going to be the attorney's first choice. In that case, it did work out and it was a safety issue, but in other cases they might not want to put your vendors in danger by quote, trespassing on someone's property.
But the governing documents do usually allow for the association to enter onto someone's lot or into their unit to make repairs that would be a safety concern.
Yeah, to do maintenance or work when the owner refuses to do it, yeah.